Hello everyone, this is Lewis. Welcome to the channel. If this is your first time here, well, thank you for dropping by. Today we are going to have a little discussion on estate planning. To a lot of us, estate planning seems to be for the well-to-do individuals. But the truth is, if you have money, a home, properties, or even a bank account, you have an estate, then you need an estate plan. However, I won't use the big word estate planning because this is very confusing. I would just simply call it wealth transfer to the next generation. Now, the wealth transfer strategy is nothing more than to understand all the different taxation and also to find some appropriate means to transfer the remaining assets to our loved ones. Now, whenever I talk to people about estate planning, the standard response would be, well, I don't have much. Or, my wife knows what to do. But really, does she? My children love each other. Don't worry, they will take care of each other. But really, can they? And also, will they? Yes, it is extremely uncomfortable to think and talk about death. But a well-prepared estate plan can help you leave a legacy, protect the surviving loved ones, and to reduce taxes. Also, you have to remember disputes between family members after your death can be very costly and time-consuming. Now, you should let your family members know the reason for your estate plan. And if you are not comfortable discussing it now with them while you're still alive, then you should attach a note to your will explaining the reasons behind your wishes. For your estate plan, the first thing is to list out what you have. It should include home, vacation properties, share of any businesses, investments such as RSPs, RIFs, TFSAs, bank accounts, pensions, or other personal properties such as jewelry, personal and group insurance policy as well. Now, don't forget to list out any outstanding mortgages and outstanding debts. The next step is to decide who gets what. Now, you must figure out how to distribute your assets to family members or to charity. But make sure you understand, fair does not mean equal, and equal may not be fair. Now, make sure CRA is not another beneficiary to your estate. You need to understand, at the time of your death, you are deemed to dispose all of your capital property, and the estate will have to cover the tax on any capital gains. Tax shelter assets such as RSPs and RIFs will lose their tax shelter status and become fully taxable. Of course, you can roll over these assets to your spouse free of tax, but eventually the tax will have to be paid after the second death. In addition, you need to know the estate must pay probate fees to the government to confirm the validity of your will. Now, there are many ways to distribute your assets. Let's take a look at one of the distribution methods during your lifetime. You can give or loan money to your children. You can have joint ownership with your intended recipient to any property. Designate beneficiary on your registered plans and insurance policies. Consider using either a living trust or a testamentary trust after your death. Another method to distribute your assets is through a will. A sound estate plan always involves a will. The will is really the cornerstone of your wealth transfer plan. It lets your executor know your wishes regarding the distribution of your estate. Without a will, the estate will be settled according to the intestacy laws of the province. It is important for you to identify several individuals that you can trust to look after your affairs in case of death or incapacity. The first one is the executor. This is the most important person to carry out your wish in the event of your death. This person must have some basic understanding of legal matters and can find the time to work on your estate. Sometimes it may not be a good idea to name your spouse or your children as executor unless they have the time and comfortable with numbers and have some basic knowledge of the law. Otherwise, it may be a better idea to name a professional from a bank or a trust company to act as your executor. The next one is the enduring power of attorney for property. Now, this gives the individual the legal authority to manage your financial affairs if you become incapacitated and unable to manage your own affairs. This person must be very detail-oriented and familiar with all financial matters. He or she do almost anything the same as you would have done for yourself. Now, except he or she cannot name or change beneficiary or write a new will for you. Another person is the power of attorney for personal care. Now, this person can make medical decisions such as continuing life support and other similar important medical decisions, or the future health care for you. This person may be called upon to make decisions quickly. Therefore, he or she should live in the general area to you. Another person is the guardian for the children. This person is to look after your children should both you and your spouse were to die when they are minors. This person should share the same parenting views as you and your spouse. You can also name a separate person to look after the financial for the children, but of course, this all can be from the same person. Now, the power of attorney will generally take effect if you become incapacitated, but you may also indicate other triggering conditions in the document as well. Make sure you understand a living will is not the same as your last will and testament. A living will is basically an advanced medical instruction that you provide your doctors and caregivers on the kind of medical care that you want or do not want whenever you are incapable of making those decisions for yourself. Now, it may be part of your power of attorney, or you can put it in a separate document. Now, besides your will, you may also need a copy of your marriage contract. Each province has its own matrimonial property laws, but if you wish to protect specific property, then a marriage contract can assist. Another one is the cohabitation agreement. Common law relationships are not subject to matrimonial laws and have little protection from the provincial marital property laws. If you are in a common law relationship, then you may want to consider a cohabitation agreement to set out the financial terms and conditions of your relationship. Make sure your executor knows whereabouts of these documents. Also, it is a good idea to have a master list of all your assets and accounts to provide for the executor, but make sure you keep them in a safe place. There is another side of planning that most people are not aware of. Things such as business succession plan. Now, you need to decide what will happen to the business that you own in part or in whole. Is it going to be sold, or do you plan passing it on to your heirs? Funeral arrangement, burial plots, cremation or prepaid funeral. Organ donor cards. If you would like your organs to be donated to someone, then you need to discuss this with your family first, as doctors will need their consent. Long-term care. If you end up requiring long-term care, would you like to age at home, the private care home, or the government-subsidized LTC facilities? Now make sure you understand, could you afford to age at home or move into a private care facilities? Now, last but not least, you need to update your estate plan. If there's ever a change in family dynamics, such as divorce, marriage, or birth of a child, acquisition or sale of a business, major financial change, such as inheritance or a lottery win, death or unable to act from your executor or power attorneys, death, ill health, or other reasons of one of your beneficiaries. Your estate plan will change as you move through life. In your 30s and 40s, Your priorities may be just to provide an income for your spouse and children during their dependency period, caring for the children in the event of premature death of both you or your spouse. But in your 50s and 60s, you need to ensure your wealth will be transferred in the most tax-efficient way. It may also include a legacy to help your grandchildren. Allocate funds to help aging parents with their health-related costs. As I always mention, your priorities may change as you move through life. It is a good idea to revisit your estate plan every 3 to 5 years. Now, that's all for today, and thank you for sharing your time with us. I hope you find the information useful, and if you enjoyed the video, please give us a thumbs up and subscribe. Until the next episode, do take good care of yourself, and I look forward to seeing you again soon. Goodbye.